forward.
Yes.
Then with the remaining cases, there is a process that they can execute that literally consolidates the cases into a single case number.
Okay.
So the old case numbers won't be displayed as dismissals. They will simply just be consolidated into a single case number. That single case number would likely have multiplicity of violations. And the items from consolidated cases would then appear in the docket of the sole unified case, so to speak.
What would you require from us, Your Honor?
I would just need to know, once I got the order, if it had a schedule or a spreadsheet attached to it, letting me know we want to keep this case, these are the cases to be consolidated into the single case. Then I can give that to the clerk's office and they can go through that process to consolidate those cases. The case numbers that are, let's say, no longer used, of course, are eligible to be recycled for other cases unrelated to this, but they will no longer be case numbers related to Woodland Heights Apartments. It would just be whatever of the remaining case or case numbers that y'all want remaining to be consolidated into. Maybe that will also be a good point of proceeding on two cases, one with main exterior violations in a separate case with multiple counts, essentially to be a case with multiple counts because it would be different units involved in those cases. And
Your Honor, just for clarity, some of the units have interior and exterior. So there may be one unit D, 103, and it may be exterior violations as well as interior violations in that particular unit. So they're not all as easily or readily bifurcated in that way, but we can definitely work to that goal.
In that case, if it's easier just to do it, with an eye towards a single case number, then that's fine too. And I'll also, obviously, I'm speaking off the top. I'll make sure that they can do what I'm saying. I hate to represent to y'all that they can do this, and I go down and they tell me that that's impossible. Yeah, but I'll make sure that is a possibility. But we'll work to make sure there's a mechanism to kind of get everything to where it looks like it's something that's manageable to actually go forward. I guess on the property side, assuming that we move forward with these dates as scheduled, is there a willingness to work with the city in the interim to bring some of the issues into compliance such that they're not an issue to even have to be dealt with if we end up at a July hearing date?
Oh, absolutely, Judge. It's my hope and I think reasonable anticipation that we may not even need the July hearing date, but we want it to kind of give us a framework as to how we're going to progress forward. Absolutely, I think if not, it's possible the entirety is not resolved and maybe we come to an agreement as far as a consent order on the case. But I think at minimum what we're here arguing about and hearing evidence on July 24 is going to be a lot narrower than what you're saying on your docket right now.
From physically going to the property, what percentage of these violations from your viewpoint are capable of being brought into compliance by or before July the 24th?
All of them have the potential to be complied by July 24th.
From your lips to God's ears. That's what we're hoping for.
So I guess y'all will submit something in writing, but I just want to make sure I've got 6/14. The city is going to provide a more definitive statement of violations to the property to the defendant. July 5th, the defendant will have provided written responses and presented any motions that need to be filed in the case. By July 19th, the city will have responded to any of the motions to the extent that they have been filed. And then by July the 24th, assuming that things are still unresolved or any issues that are unresolved, we'll be looking for a final evidentiary hearing and take up any pre-trial issues that remain that morning.
Yes.
That makes sense, Judge. And I apologize because I didn't mention this to Ms. Bowles, but it just occurred to me as we were talking about it. But in the unlikely event we end up having to go forward on an evidentiary hearing, if we could include some sort of kind of deadline for production of the evidence the city intends to put on at trial, so that we know what we're responding to. I don't know what the universe of that looks like, but we can serve formal discovery, but I think we can probably just exchange what each other have at an agreed date. I just wanted to mention it here in front of you so that we're on the same page.
I think, assuming that the bulk of what will be needed, I guess is available now, the bulk, I wouldn't say everything, but maybe the bulk, maybe by that July 19th date, that should have been received on the defense side, because at that point, we're looking at a week from the 19th being, the hearing, and you would have photographs, anything, whether it's for you to look at, but also for the court's benefit, that some of those things may be stipulated to, so that they're not an issue of needing framework laid to even introduce them. So hopefully before then, y'all will receive everything.
Okay.
I imagine that most of it's going to be photographs.
That's what I would be anticipating.
The city's evidence would be the inspection,
Okay.
the photographs, testimony from our officer.
I'm not asking to take Officer English's deposition here.
Understood.
And, quite honestly, we're very interested and curious to see what type of motions could be filed when you say the violation is a broken window. I'm not sure what motion results from broken window, but we'll be happy to explore that and consider it when it's received.
Well,
And, Your Honor, we also will be seeking fines, violations, and we can talk about that at a later time, but generally the range, the code allows us to seek anywhere between $250 to $1,000 per violation. So we do intend to proceed in that regard.
I'll have some arguments on that, but I think we can cross that bridge when we get to it.
well, I'm certain that between the lawyers for both sides, there will not be a lack of creativity for making both sides points, and unfortunately, I'll have to sort that part out. But I'm at least optimistic that council is talking, and that some of these things, for the benefit of the residents who live there, the benefit of the surrounding community, will be resolved such that we're not talking about this universe of issues as a much more narrow approach to what this court will have to decide as far as the violation, if any. I'll be optimistic that that may not even be the result by the time we get to July the 24th.
Because ultimately, the city's goal is to have the violations complied so that the residents are in safe and secure housing, right? So unfortunately, we have to go through this process to get some of their rights resolved, but we're here for it, we're ready.
All right.
Thank you, Your Honor.
Thank you. I'll make just a general announcement to the folks here so they can just understand in plain words what's happening and what was the point of today. Ladies and gentlemen, I understand that the remaining folks who are in the gallery are directly related to this case by virtue of being a resident at the complex. This morning was the initial appearance for the notices of violation that were scheduled to be heard in this court. And as y'all know, there are a lot of alleged violations. My calendar that I'm looking at has over 100 different positions related to the property, which is a lot. This isn't a case where there's a single ticket with one or two items. So obviously, being able to determine the best way to proceed and make use of everybody's time is very important, because some of you may actually end up having to provide testimony in the case, and being able to give you a day and time that will happen is very important. The gentleman in the blue is the attorney on behalf of the property owners, and Ms. Bowles in the tan jacket is the special prosecutor for the city of Atlanta. The two lawyers have talked, and they agree that there are a number of violations, and they're going to work to combine all of those violations into a single case, so that we are having one case that we're operating from as opposed to 100. They're going to do that, and they're also going to do some lawyer work as well. The city is going to provide to the property a more detailed statement of what the violations at the property actually are. The property is going to respond to that, as well as work with their folks on the ground to start getting some of the items that everybody agrees is an issue taken care of. The parties have asked that this court set a final evidence hearing for July the 24th, meaning that if things are not taken care of by the time we get to July 4th, then this court will have to ultimately decide what happens with the case, what happens with those violations. However, the parties anticipate that many, if not most, optimistic, if not all of these issues are taken care of before then. The city will simply be coming back asking that a fine be imposed for these violations, and of course the property will be voicing their opposition to that fine amount, whatever it may be, but that'll be something that the court decides. You can check the status of this case online, but most importantly, I'm telling you now that if all else fails, there will be a final hearing on July the 24th. So if nobody else contacts you, you know that you can come back on July the 24th and see and hear exactly what has developed over time with the case. Obviously, the best case will be as you get back home, you'll see that people are doing work and trying to contact you to get that taken care of. But nonetheless, I will be the judge handling the final hearing, and you're very welcome to participate in the courtroom at any point. And I am not in a position to give you legal advice, so before I take your question, I'll let you speak with the attorney for the city of Atlanta, because she actually represents your issues and your interest in this case. And I'm happy to speak with you, but I have to be very careful about what I hear from you, because right now I don't know anything about your case other than what I have in front of me, and it should stay that way until we actually have a final hearing and I actually hear evidence that's being put on from both sides. Because anything I hear now could potentially prejudice me, and the defense attorney would be asking that that change as far as who's hearing the case, and that will only delay this any longer. So I'll let you speak with Ms. Bowles first, just to tell her what is the issue that you want to speak with me about, and she'll be able to tell you if that's something that I can actually address for you this morning. But I'm happy to do it if it's something that's in fair game for me to be able to do. Okay?
Judge, if I could just provide one point of clarification. I think this happened before. Yeah, residents are of course welcome to attend any of the trials and hearings, but when you see the notices posted in the hallway, it's not because you're here as a defendant. You know, it's noticed that this hearing is happening. So I just want to make clear with that. I think we had an issue before with that.
And Ms. Bowles, before I hear from that, I just wanted to make sure it's not something that's out of bounds.
Yes.